friends, I can tell you that when the ex-spouse starts playing the calendar games and all of a sudden, as a result, the other parent either misses their time sharing and visitation with the children entirely or part of it, it is not just frustrating, it can be heartbreaking, especially if it occurs or happens on the children's birthday. Let's say they're little and it's a milestone birthday or a quinceañera or a sweet 16, or maybe there was a plan to go to Orlando to spend the birthday at Disney World. Or, for example, if it happens during summer break and the parent who misses the time sharing had an awesome vacation plan somewhere. Or if it occurs during the holidays, let's say the parent wanted to spend time with the grandparents and the children during Hanukkah or Christmas, traveling somewhere, and then the other parent, the ex-spouse, says, you're not having any time sharing during these time periods. Well, it can be devastating and really difficult to manage and address. But the good news is that Florida law has your back. So today we're going to be diving into make-up time sharing and how to enforce it, especially when that ex-spouse goes rogue. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so the playbook for make-up time sharing in the state of Florida is Florida Statute 61.13, subsection 4, a very fascinating statute. But before I jump into the statute and explain how it relates to make-up time sharing, I would be remiss if I did not clear up one myth right off the bat, and that is just because someone skips child support doesn't mean that the other parent can skip time sharing or visitation, and vice versa. Remember that child support and time sharing or visitation are on two different legal tracks and have to be dealt with separately and on different parts of the proceedings. Likewise, if one parent withholds visitation, that doesn't allow for the other parent to stop paying child support or alimony. As I mentioned, both issues are separate and you cannot use one to try to enforce or withhold the other. That is not allowed by Florida law. So, what happens if one of the ex-spouses is denying the other ex-spouse time sharing or visitation with the children? Well, if one of the exes has been playing the hiding game with the children or not allowing for time sharing, Florida law says that that parent who has missed time sharing is entitled to make up time sharing. So let's break down how that works. Here is what a court must do when dealing with make up time sharing under Florida Statute 61.13, subsection 4. And when I say must, the way that the statute reads is that the court shall do all of the following. So it is required. The first thing that the court will do is that it will calculate the missed time sharing for the parent who was denied time sharing. So if it's been a week or it was a weekend or maybe it was summer break, the court will actually do the math and figure out how much time sharing was actually missed by the parent who was denied time sharing. Next, the court is going to give that parent extra time to make up for the missed time sharing as quickly and as conveniently as possible, which is huge. It's not something that's going to happen a couple years down the road. It's something that the courts want to remedy as soon as possible. And here's the kicker, which is number 3. So long as the make-up time sharing is consistent with the best interest of the children, it must be scheduled at the convenience of the spouse who missed time sharing and at the expense and oftentimes the inconvenience of the spouse who denied time sharing. And I think that is a very powerful remedy because, as I mentioned in the 3 steps, calculating the time, then trying to figure out as soon as possible, but also at the convenience of the person who missed time sharing and at the expense, meaning that if there's tickets that have to be bought or bus or car fare or Uber, that has to be paid by the parent who denied the time sharing. Very powerful stuff. Let's now give some examples of what I have been talking about. For instance, if one parent denies the other parent visitation during spring break, The court, if it finds out that it was an entire week, can conceivably give the parent who missed time sharing a week vacation, either during summertime or the entire Thanksgiving break or maybe even winter break, in order to make up for that time sharing as soon as possible. Let's give another example. Let's say that one parent was denied visitation on every other weekend, maybe 2 times during the last month. Well, the court could conceivably give that parent several weekends in a row just to make up for that time sharing. And finally, in the example of where a parent has dinners and the other parent denied them for the children to have dinner with them, the court conceivably could give that parent overnight time sharing during the week or additional time on the weekend to make up that time. And remember, as I mentioned, this is not a vague promise. A lot of times you'll read the statute and it'll say may, or the court has discretion to do this. This statute 61.13 subsection 4 makes the court or makes the judge required to give the make-up time sharing. Furthermore, we must keep in mind that there are other legal remedies and there are other consequences when one spouse prohibits or denies time sharing to the other spouse. The law does not stop just at make-up time sharing. The court can conceivably slap that former spouse with severe consequences if they don't follow the time sharing schedule. And some of the consequences for violating time sharing are as follows. The first of which is an imposition of attorney's fees, especially if there's a prevailing party provision in the parenting plan or it is egregious. And a lot of times, what is the excuse for not engaging in the time sharing schedule? So the court may impose attorney's fees against the spouse who's not following the time sharing schedule. The court may also require that spouse to take a parenting course. And those parenting courses, they are expensive and they vary in terms of how long they may be. It may be a month long, it may be several months long, it could be 6 months long. I've seen these parenting courses take a long time. They can also require that parent who is not engaging in a time sharing or who is prohibiting the time sharing with the other spouse to engage in community service. Do they like to go to the side of the road and pick up garbage or go out and clean up the community? Well, if they don't like it, they might as well get used to it if they deny time sharing to the other parent, because this is a sanction that is contained in the Florida statutes. Also, the parent who denied the time sharing, they can be required to pick up the financial burden or the cost of making sure that that time sharing occurs in the future. One of the more extreme remedies is that the court can use examples of a parent not following the time sharing schedule to modify the parenting plan. So these are all very serious consequences. Let's now give some examples. Let's say the ex-spouse who is denying the visitation moves 100 miles away. They go to court. The court can conceivably require that spouse who moved 100 miles away to cover the cost of transportation during visitation or time sharing with the other spouse as a sanction. So they may have to pay airfare or gas or transportation. Another good example is a person who offends consistently, someone who is a multiple time offender of violating time sharing during the week or on the holidays. The court can conceivably cut back their weekday time sharing or their time sharing during the week as well as their holiday time sharing in order to curtail this type of behavior. The court has a lot of discretion within those different sanctions or remedies in order to fit the appropriate remedy for the case at hand. All right, before we sign off on this video, I thought it would be important for us to get practical, talk about some tips and strategies as to how to present or prove the case when the issue is make-up time sharing or where a parent tries to enforce their missed time sharing. And the first tip would be to keep a log. That's right, keep a log of the missed time sharing, whether it be on a pad and paper on one of those old school calendars, or nowadays with the applications like Talking Parents or Our Family Wizard. It's easy to communicate, but make sure we're taking pictures of the screenshots or saving the emails of the missed time sharing. Tip number 2, be consistent and calm. The parent who missed the time sharing has to show the court that they aren't part of the problem. They must attempt to go to each and every time sharing situation, even when the other parent does not show up. It is something that the court likes to see, and that is consistency. And tip number 3, the parent who misses time sharing should file smartly. Don't wait months. If you wait till the child turns 18 or close to 18, guess what? The child's probably not going to want to spend time with you anyway, but it's too late. It's too far away. This is something that should be filed contemporaneously when the missed time sharing occurs. And in that motion for missed time sharing, remember the other consequences. Ask for attorney's fees. Ask for the other parent to have to take a parenting course. Ask for sanctions or costs of transportation. So we'll give some examples real quick. Let's say that a mom canceled time sharing for the dad for spring break this past March. Well, in that situation, the parent who missed time sharing, they should file the motion and ask for time sharing either in the summer or one of the upcoming holidays in the fall or in the winter for a week to try to make up that time sharing. And in that motion, there should be mention about attorney's fees and costs. It's just an example. Obviously, we don't know too much about the facts in that example. And remember that each case is different, and the sanctions and the court's decision in each case will obviously be different. All right, so the bottom line is that time with your children is absolutely precious, especially when they're little and cute as they get to those preteen and teenage years. You know how it goes. But either way, Florida law recognizes how precious this time is with your children. So if the ex-spouse is playing games and denying time sharing, document, file, and enforce, baby. Florida courts, although they are not perfect, if you use them strategically, they will get you the makeup time or the time that you and your children deserve with each other. So that is a wrap. If you know anyone that is going through this type of situation, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor. If you have gone through this type of situation, drop us a comment and tell us how the ex has not allowed or has denied your time sharing. Do us a favor and like this video. Subscribe to the Divorce Broadcast, and we will talk to you again soon.